You think a school or a church is just a building where good things are supposed to happen, and most of the time that is true, but sometimes the people inside fail the very people they are supposed to protect. When abuse happens at the hands of staff, the legal question is never just about the individual who did it. It becomes about the institution that hired them, trained them, or looked away. This is where a legal idea called negligent supervision comes into play, and it sounds fancy, but it just means the place in charge did not keep a close enough eye on things. Think of it like a babysitter who falls asleep on the couch while the toddler finds a marker and redecorates the living room walls. Except the stakes here are unimaginably higher and the harm is permanent. Lawyers chasing these cases often look for something called a pattern of knowledge, which basically means, did the institution know or should they have known something was wrong? If there were warning signs, complaints, or even whispers in the hallway that got ignored, that knowledge can turn a tragedy into a legal claim against deep pockets instead of just one person. Now here's a twist that surprises a lot of people. You can often sue the institution even if the abuser is never criminally convicted. Criminal court and civil court are like two different referees watching the same game. One decides if someone goes to jail, the other decides if someone owes money for the harm they allowed to happen. Statutes of limitations used to be the villain in this story, slamming the door shut on survivors before they were even ready to talk. But many states have passed what are called look-back windows, basically a temporary reopening of that door, giving adults who were abused as children years or even decades later a chance to finally file a claim. You might be wondering why these cases take so long, and it is not because lawyers enjoy suspense like it is a Netflix drama. Institutions usually have insurance companies, internal review boards, and a small army of defense attorneys. So building a case that can survive that pressure takes real time and real evidence. Evidence in these cases is not just about a single moment, it is about the paper trail. Personnel files, prior complaint records, training documents, and even text messages can all become puzzle pieces that prove the institution failed in its duty of care. Here is a misunderstanding that trips people up constantly. They think reporting to the police is the same as filing a civil claim, but it is not. You can report a crime and separately pursue a civil case for damages, and honestly, doing both often strengthens the overall outcome for the survivor. Damages in these cases usually cover more than just hospital bills because trauma is not a one-time expense. Therapy costs, lost wages from missed work, and something called pain and suffering, which puts a dollar value on emotional harm, are all things a good attorney will fight to include. Religious institutions add a unique twist because of something called the First Amendment, which protects religious freedom. Lawyers have to be careful to frame claims around negligence and supervision rather than challenging religious doctrine itself, because courts are very protective of that separation. Schools, meanwhile, often hide behind something called governmental immunity if they are public institutions, which can limit how much money you can recover or how fast you have to file. This is exactly why timing and local law knowledge matter so much, because every state plays this game with slightly different rules. You might think going up against a massive institution with lawyers and lobbyists is hopeless, like bringing a water gun to a flamethrower fight. But survivor lawsuits have taken down entire organizations before, forcing policy changes, public apologies, and settlements that reached into the millions. There is also a quieter purpose behind these lawsuits beyond money, and that is forcing transparency. When institutions are forced to release records during a lawsuit, it often exposes systemic failures that protect future children and future families from experiencing the same nightmare. If you or someone you know is wrestling with whether to come forward, know that there is no perfect time and there is no expiration date on your right to seek truth. Preparation, documentation, and the right legal guidance can turn an impossible feeling into an actionable path forward. So if any of this hit close to home or you just want to understand your options better, do you want to learn more about how we help people in situations exactly like this? Check out our links in the description.